Peace, everyone. Welcome to the Moroccan Post School of Government and International Law Advanced Study Group. We have those who are not aware. We have the Moroccan Post School of Government and International Law Advanced Study Group Telegram page. Someone put the invite link. I can put the invite link later to the Telegram. We got about over 100, I guess, members to the Telegram group coming your way soon. Get your tickets. Get your tickets now. All right, coming your way, the Moorish Governance, Birthright, and Nationality Claim Conference coming your way on May 18th, next month. Next month at Majestic Hall, 800 West Alney Avenue, Philadelphia, Pennsylvania. I can't increase the size, Terrence.
Yeah, you won't be able to. It's on a whole nother program.
All right, so would I be able to read the other text material?
Can anyone else read it? Read what's going on here?
Yeah, we're just showing the flyer, but it's yeah, I can't see. Well, I mean, I know what it is, but I'm just looking at the other material that I'm gonna have to read.
All right, give me a second. I'll
Yes, sir.
yeah, I'll blow it up large enough for you to be able to read it.
All right, so no problem. All right, so just coming your way soon. This get your tickets, go to for the Eventbrite link and the flyer. You can go to Abdullah Bey's Facebook page. I have the flyer and the Eventbrite link pinned on my page, the Abdullah Bey Facebook page. So definitely we have a host of we have the keynote speakers and panelists, and I will have we had Pakola Lee Kusar Il for the past on Moorish Monday with Abdullah Il Talimosi Bey, the Magna Crystal Pyramid YouTube page. And she had part 1 and 2 of the ancient matriarchal print, restoring the knowledge of the ancient matriarchal matrilineal principles of civilization. She did a wonderful job with the past 2 Mondays. And I'll have other keynote speakers. I have this coming Monday, Brother Vicerious, Ill. We have Anthony Hurd and Quasi Ill will be my next guest on Monday, April 8th. Then I have April 15th. I have Nakeem Bey. I have um, Al-Kanan and Raymond Edwards. These are my Masonic connections. They will be on together on May 15th. And I'll have that lineup posted on my Facebook page and the Telegram page, a lineup of all the keynote speakers and panelists on Moorish Monday. This is a way of our introducing. You get a chance to know the keynote speakers and panelists on Moorish Monday. All right. We'll have King Il Bey and Shir Malachi Bey on May 13th. They'll be the last one leading up into the conference. Right. So go to the next one, Terrence.
All right.
All right, we got a few more people be coming on, as we continue.
All right.
We got to do.
The next thing we have is the session. So here it goes.
All right.
Boom.
All right, so this is the seal for the Moroccan Post School of Government and International Law.
Right, everybody's coming in, so give me one second.
The Moroccan Post School of Government and International Law is sponsoring the Moorish Governance, Birthright, and Nationality Claim Conference. So this is we started on February. This will end the second Thursday of August will be the last study group session. All right, so we have the Advanced Study Group Session 5 today, April 4th, 2024. Topic for the day, proving the claims to disprove the misconceptions, claims taught by conscious Moors for several decades, Part 3, the history and jurisprudence of Article 6 of the United States Constitution, the basis of the British subjects drafters of the United States Constitution claim that the United States Constitution is the supreme law of the land. It does mention that treaties are as well, but it also mentions that now this Constitution and treaties made we'll read that later on. All right. Teacher, we have Terrence Bay, co-founder and administrator. Shem Malachi Bay, co-founder, curriculum developer, and teacher. Abdullah Il Tilimosi Bay, co-founder, curriculum developer, and teacher. King El Bay, teacher. Razil, I added to the list. We have Rasirius Il, teacher. Quasi Il, teacher. Pokola Lee Kusar Il, teacher. Anitria Butler Ngungi, teacher and curriculum developer. We have Elkanan Ani Ali, teacher, curriculum developer, and Kono. It's a Kono Bay. I couldn't recall as I was typing this today, brother. Kono Bay teacher. So we're expanding. We're expanding the school. We were talking about language studies, social studies, agriculture. Thank you. History, law, as philosophy. So we have the school will be sponsoring elementary, middle school, and high school level education in our unconscious Moorish communities in 2025. The school will also be facilitating teachers seminars in 2025. We are very serious. We're focusing, and like you said, we expanded the list. Advanced Study Group Telegram page. We have the community. We have we're going to be facilitating the communities and social media outreach network. The plan is to have 100 social media organizations, body politics that will be part of this social media and community outreach. Those who do have community outreach through social media and actual boots on the ground community. All right, we're very serious and we're very focused. This leads into the facilitating Moorish national political unity, or restoring Moorish national political unity among our people. It has to be done through structure. Free recorded courses and seminars on the Moroccan Post Media YouTube page. Moorish Government Body Politic, Constitution, and Governmental Principle course. These are 12 PowerPoint classes. 12 this is a course. It makes up of 12 classes, hour long, of PowerPoint discussions and an hour of question and answer, each one. So we're structured here. Moorish Treaty Protection and Consular Relations course 101. Moorish Treaty Protection and Consular Relations course 201. These are PowerPoint presentations. The upcoming study book seminar are supplementing the recorded courses. Treaty Enforcement and International Law study book, Consular Notification study book, Central Authority study book, Writ of Quo Warranto study book, Letter of Rockefeller study book, Moorish Body Politics study book. This is how we facilitate education among the hundreds of thousands to millions of our people. You cannot facilitate education among the hundreds of thousands to millions of people without a structure. You need curriculum, you need teachers, you need outreach, you need structure. That's just how it's done. Whoever defines the language controls the issue. The basic tool for the manipulation of reality is the manipulation of words. If you can control the meaning of words, you can control the people who must use them. Philip K. Dick. All right, session 1, orientation. That was February 1st, 2024. Sir Malachi Bey's history of developing his proposal for a plan to facilitate the restoration of Moorish national political unity and the purpose of the Moorish Governance, Birthright, and Nationality Claim Conference on May 18, 2024 in Philadelphia, Pennsylvania, the Lenadohawkee Territory. Moorish Governance, Birthright, and Nationality Claim Conference in Philadelphia on May 18, 2024, a political mechanism of restoring the domestic and international politics to protect and secure the common good of our people, both conscious Moors and unconscious Moors. and to serve as the caretaker and voice for them among the family and nations. Session 2, which was February 15, 2024, developing jurisdictional competency among the Moors through the analysis of jurisdictional incompetency. What can a Moor accomplish individually outside the Moorish treaties to help the millions of conscious and unconscious Moors? Moorish nationality and pre-existing Moorish treaty, Moorish sovereignty, Moorish nationality and diplomatic protection, Moorish nationality and consular protection. Session number 3, which was March 7, 2024, proving the claims to disprove the misconceptions claims taught by conscious Moors for several decades. Part 1. Claim 1. The construction of the United States Constitution is the continuation of European conquest and colonization as the game plan and instrument to maintain control of our Moorish estates. I think I presented that, showed evidence last week, 2 weeks ago, and we looked at Article 2. Article 2 of the definitive 1783 definitive peace treaty between Great Britain and the United States. You know, that is the Northwest Territory. You know, so the survey language is in Article 2, all right, where Great Britain received that through treaty from France in 1763 treaty between Great Britain and France. So that then it was handed over to Virginia assumed rights under that 1707 charter. So these are points there. So look at that class again. That's a very comprehensive class. This is the session 3, actually last week's session. So we have here claim 2, Moorish Americans are neither part and parcel nor part and partial of the United States government. Claim 3, Moorish Americans are part and parcel to the land and not to this said government. Claim 4, Moors are not we the people of the United States in the preamble of the United States Constitution. Claim 5, the United States Constitution is not the Moorish Constitution. Claim 6, the United States federal government is not the Moorish government. This was 2 weeks ago, the last class, session 4, March 21st, 2004, proving the claims to disprove the misconception claims taught by conscious Moors for several decades. Part 2, the history and politics surrounding the Northwest Territory and the Northwest Ordinance of 1787, from France to England, that's Great Britain, to Virginia Colony, to Virginia State, to United States and Congress assembled, the settlement of huge land disputes of the 13 original states over a vast portion of Moorish land, a major issue surrounding the United States Constitutional Convention of 1787, settling major land disputes over Moorish lands among the 13 original states and shaping the structure for future states to enter the Union. The 1763 Royal Proclamation, Article 2 of the 1783 Definitive Peace Treaty between Great Britain and the United States, and the Northwest Ordinance of 1787. After y'all go through this course here, this study session, you should be able to walk in any high school in the country, college, any high school, and teach. You're not going to learn, you're going to be teaching. They're not teaching this on this level. You'll go to teach. You're not going to go to learn. You go to teach. You know this. You'll be above all the Europeans in these colleges, above all of them. Now, the United States Supreme Court justices, that's a different story. So this is foundation. This is foundation. All right, today's session, April 4th, 2024, proving the claims to disprove the misconception claims taught by conscious Moors for several decades, Part 3, the history and jurisprudence of Article 6 of the United States Constitution. The basis of the British subjects, drafters of the United States Constitution, claim that the United States Constitution is the supreme law of the land. Claim 1, the foundational authority of each of the 13 original states to operate its political body and authority as a state in the survey boundaries within each of the 13 English-British charters is derived from the conquest sovereign power of England/Great Britain, relinquished, granted to each of the states through Article 1 of the 1783 Definitive Peace Treaty between Great Britain and United States. Claim 2, the personal rights, land, grants, towns, religious societies, educational institutions granted to the Spanish subjects by the Spanish crown, to the French subjects by the French crown, to the English-British subjects by the English-British crown during the 1500s, 1600s, 1700s are protected by the treaties with the United States under Article 3, Section 2, and Article 6 of the United States Constitution. So you see how we bringing that in play? See how we bringing, Spanish land, Spanish crown, and Spanish land grants, French crown, Spanish land grants. How we bring that into play. See that back in colonial times, see how they, set the narrative that is over. See, set the narrative that's over, that colonization no more. Back in colonial times, colonization no more. So it's about proper concepts. We cannot be effective. We cannot be effective with misconceptions. You can do whatever you do. You're going to be like a hamster on a hamster wheel. A hamster on a hamster wheel. You're moving in the same place. You're not moving forward. You're moving in the same spot. All right, so we have session 6, which is in the next session, April 18th, 2024. Developing jurisdictional competency among the Moors through the analysis of jurisdictional incompetency. What can a Moor accomplish individually outside the Moorish treaties to help the millions of conscious and unconscious Moors? Does the judicial power of Article 3, Section 2 of the United States Constitution extend to Moorish cases? Does Article 3, Section 3 of the United States Constitution extend to compensatory extraterritoriality, extraterritorial consular jurisdiction, and foreign consular courts established through treaties? Does the United States and the United States Constitution have jurisdiction over our pre-existing Moorish sovereignty, Moorish treaties, and Moorish treaty protection of the 1500s, 1600s, 1700s, and 1800s? Pre-existing compensatory extraterritoriality, extraterritorial consular jurisdiction, pre-existing Moorish diplomatic relations, pre-existing Moorish consular authority, pre-existing Moorish consular court jurisdiction. I emphasize pre-existing. I should have had that bold and highlighted. Pre-existing before the establishment of the United States. Pre-existing before the establishment of the United States. So these are pre-existing obligations, pre-existing power, a pre-existing relationship with the internet, with the family of nations. Pre-existing, that, all right, re-entering the family of nations as an old and original state. So our statehood status position is older than most of the nation states that are members of the United Nations. We're older than most of the members. We're older than older than more than half of them. Older than more than half. So this, we're talking about a pre-existing power, pre-existing history. We're not looking forward. We do Sankofa. We're doing a Sankofa. That's a bird whose head is turned backwards and body is positioned forward. You have to look back. So with that, the Europeans have looked back to us. We're Atlas. They're standing on our shoulders. They're standing on our traditions. They're standing on our philosophy. They're standing on our history. They're standing on our headdresses. They're standing on our sovereign power. They're standing on our culture, philosophy, ceremonies, holidays, rituals, festivals. They're standing on that. They're not standing on something that they developed. All right. Next one, Terrence. All right. Session 7, May 2nd, 2024. That's going to be King. And session 8, June 6th, 2024. That'll be King. King L. Bay. We'll do both those sessions. Session 9, June 20th, 2024. Session 10, July 4th, 2024. Session 11, July 18th, 2024. Session 12, August 1st, 2024. Session 13, August 15th, 2024. So I'm going to have, we're going to have King L. Bay for section 7 and 8. I'm looking to have Viserius, bring Viserius in for session 9. And then maybe a Kono or Quasi, Kono or Quasi in these two. And then I'll probably bring Shim back, all right, on. Or we'll have Sister Pocola. We'll have Sister Pocola in one of these sessions. All right. So, as I said before, it would no longer be Shim and Abdullah. It will no longer just be only Shim and Abdullah. Those days are over. Those days are over. The only Shim and Abdullah days are over. All right. It'll be others as well. It'll be Shim and Abdullah. It won't be only Shim and Abdullah. Those days are over. Some classes on the Moroccan Post Media YouTube page. We can refugee to be or not to be. Judicial incompetence, points of analysis, excerpts from a Moorish body politic formation. So we'll move on from that, Terrence. People see it on the screen. All right, then I'll go to, here we go. Moorish body politic formation, 12 classes. Moorish treaty enforcement through diplomatic channels, the United States Central Authority, Part 1 and Part 2. Shim Malachi Bey discusses the enforcement of Moorish treaties in the United States jurisdiction through the Central Authority of the United States. Legislation to enforce treaties and international law. The United States courts have lawful authority to hear Moorish cases, Part 1, 2, and 3. These are on the Moorish treaty. This is on the Moorish the Moroccan Post Media YouTube page. This is on the Moroccan Post Media YouTube page. Right. A review of misconceptions taught to conscious Moors. Conscious Moors, can have a reader. Can have a reader.
A review on the misconceptions taught to conscious Moors. Conscious Moors have been taught to use the United States Constitution in place of Moorish treaties for their protection. Moors are part and parcel or part and parcel of the United States and must live the life accordingly. Point 2, Moors are, quote, we the people of the United States in the preamble to the United States Constitution. Point 3, 35 Moors were at the United States Constitutional Convention from March of 1787 to September of 1787.
Hey, hold on, Amanda. Terrence, you know what? Instead, show the screen, Terrence, because it doesn't. I want people to see it. So I want you to start over, Amanda. Just show the screen, Terrence. I want them to hear it and see it.
Can everyone see this?
All right, just show the screen. Yeah, there we go. Keep the screen up. I want them to. You're going to start again, Amanda. I want them to hear it and see it.
You can't see it?
Yeah, I couldn't see it before. I just saw Amanda. I saw the Amanda shadow thing.
Oh, hold on, wait a minute.
It's up now. It's up now.
Let me put hit spotlight. I'm sorry, go ahead.
Okay.
All right, go ahead, man. Start again.
A review on the misconceptions taught to conscious Moors. Conscious Moors have been taught to use the United States Constitution in place of Moorish treaties for their protection. Point, Moors are part and parcel or parcel of the United States and must live the life accordingly. Point, Moors are, quote, we the people of the United States, end quote, in the preamble to the United States Constitution. Point, 35 Moors were at the United States Constitutional Convention from March of September 87 to September of 1787. Point, Moors' inalienable rights are secured under the United States Constitution. Point, Moors' right to travel is secured under the United States Constitution. Point, Moors should use a judicial notice outlining the various United States Supreme Court decisions showing how the United States Constitution protects the United States citizens' inalienable right to travel. Moors have a right to invoke the First Amendment to the United States Constitution to protect their inalienable right to freedom of religion, freedom of speech, freedom of the press, freedom to assemble peaceably, and the freedom to petition the United States government for redress of grievances. Point, Moors have a right to invoke the Second Amendment to the United States Constitution to protect their inalienable rights to bear arms. Point, Moors have a right to invoke the Fourth Amendment to the United States Constitution for their protection against unreasonable search and seizure of their houses, papers, and effects, and the right to invoke to demand from European colonial states, official and officers, a Fourth Amendment warrant and probable cause. Point, Moors have a right to invoke the Fifth Amendment to the United States Constitution to protect their right against being forced to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. Point, Moors have a right to invoke the Sixth Amendment to the United States Constitution to protect their inalienable right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Thought-provoking questions concerning Moorish treaties for conscious Moors who have been taught to use the United States Constitution in place of Moorish treaties for their protection. Question 1. What does it mean in the laws of nations when the Moors who are of a foreign government with treaties with the United States of America renounce their allegiance to their government, Morocco, and pledge allegiance and seek protection to the United States? Question 2. What does it mean in the law of nations for a nation of people to rely on the constitution of a foreign power and/or government for their protection? Question 3. Can the following be implemented by using the United States Constitution and United States laws? The recovery of lost Moorish sovereignty, the enforcement of reversion to sovereignty, the international law principle of returning a people held in slavery to their original condition before slavery, known as post-liminium, Restore a national central Moorish government. Write a national constitution that will unite the Moors under Moorish national sovereignty. Enforce pre-existing bilateral Moorish treaties with France, the Netherlands, Great Britain, Denmark, Spain, the United States, Sardinia, Austria, Belgium, and Germany, which covered the period from 1631 to 1892. Negotiate treaties with other sovereign nation states. Establish Moorish embassies and consulates in foreign countries. To send Moorish ambassadors, consul generals, consuls, and consul agents to other sovereign nation states. To receive ambassadors, consul generals, and consuls and consul agents from other sovereign nation states. To trade with other nation states. Legislate the laws of a Moorish nationality and Moorish citizenship. Legislate Moorish immigration and naturalization laws. Legislate the laws of a Moorish passport. Use Moorish passport to travel outside the country and not having to be subject to a United States passport. Legislate Moorish ministries and departments.
All right, so this is by these principles. We're going to get them. We're getting this across. More and more people are getting this, you know, and we've been pounding this for 5 years. We've been pounding this for 5 years. More and more people are growing to this. And as we continue to teach this in this structural setting, these principles are not over our head. This is not complicated. What's been the problem, Abdullah? The misconceptions. If you had never been taught misconceptions, you better get it like this. Get it like that. It's the misconceptions that you have to dump. It's so that's, you know what I mean? It's bumping, you're bumping up against the misconceptions. So you hear it, it's the misconceptions are solidly bed in your mind 10 years or 5 years or 3 years or 2 years. So it's you hear this and you think about what you've been doing for the past year or 3 years or 5 years or 6 years, and you know, nah, that don't sound right. And because it doesn't sound right based on what you've been doing, you know, for 5, 6 years. I get it. It had been 25 years for me. So, but if you had not been taught misconceptions and had been taught this from the jump and get into Moorish movement consciousness, get it like this. So it's not some complicated over your head stuff. It's the misconceptions. So be clear. It's the misconceptions. That's the key. That's the stumbling block. The roadblock to getting it like this is the misconceptions. Not the information, the misconceptions. All right. Advanced Study Group Session 5, April 4th, 2024. Proving the claims to disprove the misconception claims taught by conscious Moors for several decades, Part 3. I can have a reader, another reader. We have another reader.
I can read it for you.
Right on.
The history and jurisprudence of Article 6 of the United States Constitution. The basis of the British subjects, drafters of the United States Constitution, claimed that the United States Constitution is the supreme law of the land.
All right, stop there. All right. It does read this Constitution and treaties made, this Constitution and laws of the United States and treaties made and pursuant thereof, we'll read that. No, so it does state here. So that once you read this and we'll go through the analysis. Read this excerpt here.
Excerpt of Article 6 of the United States Constitution, Supremacy Clause. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under the Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all the treaties made or which shall be under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or law of any state to the contrary notwithstanding.
All right, so the question on what is the basis of the those British subjects who fought against their mother, the British Crown? What is their basis of their claim in 1787? In 1787, when they met in Philadelphia, from March 1787 to September 1787. What is the basis of their drafting it, of their drafting this article, of making a claim that this Constitution is the supreme law of the land? It mentions treaties too, but it also mentions this Constitution. Well, what's the basis of their making that claim that this Constitution is the supreme law of the land? Come out of thin air? Did it come out of thin air? They come out their butt. I mean, what basis did they make the claim? You know, because in order to draft something in, you got to have the claim. You have to have a basis for the claim. You're not just drafting. They're not just drafting this without some authority to do it. By what authority did they have to draft that this Constitution is the supreme law of the land, of the land, the land, of the land, of the land? Can I get an answer?
Article 1 of the Definitive Peace Treaty in Great Britain and the U.S.
All right. All right, so let's go to Article 1. Let's look at Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States. We're going to look at the language in Article 1. Then bring that back up, Terrence. All right, so Article 1, so as soon as Terrence gets it back up. Does everyone else agree? All right. So we're going to go to Article 1, go down. We see, is Article 1 there? All right, so we have here. Can we have a reader here? Have a reader. Article 1. Mm-hmm.
Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States. 13 English-British colonies along the Atlantic Sea coast. His Britannic Majesty acknowledges the said United States viz. Latin for namely New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Maryland, Virginia, North Carolina, South Carolina, and Georgia to be free, sovereign, and independent states, that he treats with them as such, and for himself, his heirs, and successors, relinquishes all claims to the government, propriety, and to territorial rights of the same and every part thereof.
All right, you got here territorial rights. Here we go, territorial rights. Relinquish what? Territorial rights. So we look at the charters. Look at the 13 Massachusetts, New Hampshire's Colony Charter, Massachusetts Bay Colony Charter, Rhode Island Colony Charter, Rhode Island and Providence Plantations Colony Charter, Connecticut Colony Charter, New York Colony Charter, New Jersey Colony Charter, Pennsylvania Colony Charter, which is the William Penn Charter, Maryland Colony Charter, Virginia, Company Colony Charter, North Carolina Colony Charter, South Carolina Colony Charter, and Georgia Colony Charter. What's in the charter? What languages are in the charters?
The boundaries.
The boundaries. Territorial boundaries are in the charters. So that territorial boundaries are in the title, charters, that makes those colony charters conquesting title to land. I said conquesting. I didn't say title to land because they're going to challenge me. This ain't their land, and that somebody ready to jump on me. They about to jump on me, boy. They about to jump on me. Conquesting title. Conquesting title through land established through English-British conquest and colonization. English-British sovereignty extended on Moorish land through English-British conquest and colonization. So the English-British colony, the charters are extension of English-British sovereignty on Moorish land. That's title, that's conquesting title to land. No New Jersey state constitution is not conquesting title to land. No deed, no state deed is conquesting title to land. No deed to your house, that's not conquesting title to land. So we have here relinquished territorial rights. Relinquished territorial rights. This is the basis of their claim. This constitute, because without this treaty, they couldn't make the claim. They couldn't draft in this constitution, supreme law of the land. They could not draft that in there. Why? You got to first have the authority to do it. You got to have the authority to, before you draft, you got to have the authority to draft that language in their constitution. They have it. Here it is, Article 1. You see how detailed I'm being? Because I'm pointing to the source. I've been on this Article 1 for a year now. I've been hitting, help me out, tell him, Terrence. Tell him, Picola. I've been banging this for a year. And my knowledge base has grown every day. This is major. This is a major piece of understanding for us. Why? No, we're not parties to it. So, Abdullah, why are you spending so much time in Article 1? We're not party to this treaty. But it relates, what? How are we involved in it? Because it involves our land. It involves our land. Our land, 13 what? Along the Atlantic Sea coast. Along the Atlantic Sea coast. All right. And then you have the Northwest Territory, Michigan, that's our land. Our land is the subject, is a subject of this treaty. Our land is a subject of this treaty. Article 1, Article 2. Article 1, Article 2 of the 1783 Definitive Peace Treaty. Land is a subject of this treaty. So why is it? That's one. It's also important to know, for us to know where to go, how to address the matter. That we know that United States courts, United States Supreme Court does not have the authority. The United States Supreme Court does not have the authority. United States and the United States Supreme Court do not have the authority to sit down with us and relinquish land, that the Northwest Territory and 13 to us. They don't have that authority. Why not, Abdullah? Why doesn't the United States courts have the authority? Why can't we go to the United States Supreme Court? We want our land back. Why is that the improper venue? Why is the United States and United States courts the wrong venue for us to argue the recovery of our land? Why is that the wrong venue?
The United States is not the occupying sovereign.
No, Terrence. No,
Oh.
Terrence, not you, Terrence, not you. Never you. Never you,
Sorry,
Terrence.
sorry.
Never you, Terrence. Never you.
Sorry. You got it.
Never you, Terrence. Never. You
Because
already
it's not
know
an
this, bro.
international venue.
I'm sorry, I'm boiling in the background.
I know. You can't hear, not you,
I
Terrence.
got
No,
you. I got you.
we've been banging this for a long time with me and you. One-on-ones, brother. You know that. All right, so it's what?
Could I say something? So when we looking at contracts, we gotta look at the contractual parties in the relationship with any contract. So they're not the United States is not the sovereign in which the how I want to say the Empire of Morocco have that treaty with. So you always have to look at the people signing those treaties. The definitive treaty is between the United States and Great Britain and their relationship with the 13 colonies. But the position is the empire, we have to look at where the empire fit into this because they are the landlords over the land. And to determine who has rights to lease the land, you have to confer those treaties with the empire.
All right. We have somebody else. We have someone else. Now I'm asking questions. We
Well,
have another point.
The United
again?
States is actually requesting this independence from Great Britain anyway, so of course they wouldn't have the authority. That's one main point that I see. Is that correct?
I don't know. You tell me.
Chief,
Anybody
look,
else? Anyone else?
The United States is the occupying they're the occupying sovereign, so they can't.
United States is what? Say again?
They're the occupying sovereign over here, and so they can't grant you back.
You say United States is the occupying sovereign.
Yes.
All right. Let's analyze that, y'all. Let's go to the Article 1. Her claim is United States is the occupying sovereign. All right, read Article 1 again. Let's look at that. And we look at others.
Can I revise my claim?
All right, there we go. Go ahead.
That
Right, revise it.
Britain, it would be the occupying sovereign, but so my response then to the question would be,
All right, why? 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 Why is Great Britain, England the occupying sovereign?
from conquest. They defeated the Moors through conquest.
Can we get all right? Can we give more? Can we give explanations according to contracts? Can we speak in the language of contracts? Can you give me some source, some reference points? All right. Anyone else?
Well, in the definitive peace treaty between Great Britain and the United States, it's Great Britain who is they're relinquishing the authority over their claim over here.
All right, so that's one piece of evidence. So that's evidence. That's evidence to support her claim that Great Britain is relinquishing. United States is not relinquishing. See how you do this, y'all? You don't come out of
They
thin air.
couldn't cede- They
You
couldn't
don't
cede
make
it to the
statements out of
United
thin
States.
air.
That they couldn't cede it to the United States because the United States was not a sovereign at that time.
All right. You make Great Britain is relinquishing. So Great Britain is the one that has the superior claim.
Therefore, you're not
That's
gonna
just,
get the right.
this is not complicated. This is not complicated. It's not over, don't overthink. Don't overthink. Don't overthink. Use what's in front of you. There's no overthinking. Analyze that which you see in front of you. It's there in front of you.
His Britannic Majesty acknowledges the United States to be free, sovereign, and independent.
All right. So are you sure it doesn't read? You sure it doesn't read? United States acknowledges His Britannic Majesty. Hold on, Mike, let me clean my glasses. Hold on. Let me clean my glasses.
The glass is clear.
Hold on. United States acknowledges His Britannic Majesty. His United. Hold on. Let me clean my glasses. Hold on. You know why I'm doing this, y'all? To get your attention.
Get them thinking.
To get you to think. Don't overthink. It's just read what's in front of you. United States is not acknowledging His Britannic Majesty. United States is not relinquishing anything. United States did not establish, Maryland, New Jersey State did not establish New Jersey colony. New Jersey State did not grant New Jersey colony charter, a charter to New Jersey colony to New Jersey State did not grant a charter to Lord proprietors and the establishment of the New Jersey colony. New York State did not grant the charter in 1664 to Duke of York, King James II, Duke of York. New Jersey State did not grant that. So we're still dealing with contracts. Who's granting the authority? So we can't, so once again, the question is, why isn't, I just made the claim that the Moors, the United States and United States Supreme Courts, United States courts, do not have the authority to sit down with us and what? Give us land back. They don't have that authority. Why not?
Because they're not the occupying sovereigns.
Because they're not, because it says the 13 English British colonies. So they're British colonies.
Exactly.
That was granted. So it's Great Britain who we got to deal with this subject matter. Not the United States.
It's just look at there's no
It's
overthinking.
Look at what's there. Saying that he's
Yeah.
relinquishing all claim right there. That's what it's saying. They're relinquishing it. It's right there. Relinquishing the claim.
Yeah.
What I'm saying, I'm giving it to
Yes,
you. Here, you can have this. I'm giving you this.
For the redirection.
Yeah, I look at it like, what gave them authority to them to do anything? What gave them anything?
Islam.
All right, so let me address that.
Islam.
Real quick, Pacola, before you speak, or for you could tell, let me address that because he said it looks like it. All right, we got it. I want to address that statement. I see it. I want to address. I see it. We got to address that. You said I see it. That's an error. an analysis. I'm not
Right.
attacking. You said, I see it. You want to point to a source. You want to point us to a source and say, according to whatever, you said, I see it the way I see it. And I know that's by habit. I wanted to stretch that first, Pecola, before you go on. Because I know that's by habit, but we got to break that. You want to point to a source, not you see it. Point to a source and say, and then point it, and you read the source to us. Say, see here, it reads, according to, all right? Go ahead, Pecola.
Yeah. Oh, yeah, so I have a question. A question, and also I think a fine statement, if you will. In the early times of teaching between the Moorish relationship and the Moorish Empire and the British Empire relationship, or any of the occupying sovereigns, in the beginning, I believe it was a reference of the early treaties from the 1600s, and so it would almost imply that that there was a treaty relationship, the sovereign and sovereign, where it would not even be a discussion of occupation if it was a willing contract that was given, if you will, between, like, for instance, the New York colony territory, those territories where it was up under King James or King's, one of the king's brothers. It was given Duke of York. So
Yeah, James II.
some of those
King James,
treaties
James II.
are documents from the 1600s. If we were to look at what other treaties that the Moroccan Empire had with other nations, or even during the time that they were paying tribute to the Moors, it's kind of odd. I mean, can you explain how early treaties or early occupation in the 1600s is not viewed as colonialization or occupation, and it's really looking more or so like a contract agreement with a sovereign and a sovereign? Okay, I yield.
I'm gonna just tie this into because the question is, can United States courts and United States give us return land to us? Like, could United States courts remove the Thomas Dungan patent, and then return they give us that land? Can United States courts remove the personal rights of society of the propagated faith? Can United States courts say, we're gonna kick y'all to the curb? All right, come on, Moors. Can United States courts have that authority to do that? Can United States courts remove the Spanish land grants? 2,000 acres, 15,000 acres that was granted by the Spanish crown to families. Can United States courts say, we're going to yank that, all right? And then here come Moors. Can United States courts, United States have that authority to do that?
So can I explain it a different way?
Mm-hmm.
So just to explain it a different way, can you hear me? I'm actually in
Yes.
an area that's kind of loud.
You loud and direct.
Me.
You loud and direct.
So it kind of, okay, great. I heard you reiterate the, and then, but within that you were expressing that, of the land was at that time who they were as the United States at the time that Britain, who's almost like first in line, if you will, they actually had occupation earlier on. So I get it that was your question, but it is also, relative that when you speak about the patents and so forth, or the lord proprietors that actually had land in existence before. So the question is that was there at any point treaty relations in the 1600s with the sovereign Moroccan Empire and the colonial powers prior to the further occupation? Because couldn't they argue that there was a treaty that existed? Couldn't they argue that?
Yeah, what you said? What type of treaty though? You say a treaty. There are treaties that we have with Great Britain. Yes, Morocco. Yes, we do that. We have that.
A treaty. But that's what I'm saying is that between the sovereigns was being taught that we had treaty relations with the colonial powers in the early years before occupation, or it appears as though they took over all the land. So I'm saying is that at any point in time, could they stand on a prior agreement from the 1600s that was on the record? I don't want to belabor the class because I know you're trying to go to the next topic, and I don't want to keep beating certain topics, but I just was inquiring about that.
You have to look at there's no cession treaties. There's no cession treaties that have in Moors and Masonry are not land boundary cession treaties. There was no relinquishing there was no ceding of land. Here we're talking about land. We're talking about when my question is raised is we're talking about recovering our land. And that we've been conditioned, conscious Moors, United States. That's all we hear. United States, United States, United States court, United States courts. We've been beat over the head with that. United States over and over again. Conscious Moors have not heard this level. This is a different, now we look, so I like the question once again, can we the Moors, or can the United States courts have the authority? Does Joe Biden have the authority to call us to the White House, sit us down, and say, we're going to remove the Spanish land grants and get you the land? We're going to remove the personal rights. We're going to remove North Carolina authority, South Carolina, New Jersey. We're going to remove New Jersey state does have no right claim to no land here. Joe Biden saying that. North Carolina state has no right to claim here. Joe Biden saying that. South Carolina. Can Joe Biden say that? Can Joe Biden, all right, kick New Jersey state to the curve, South Carolina state to the curve? Can Joe Biden do that? Can United States courts do that? That's the question. Because this is major, because we have to know where we have to have a clear direction to go to argue our claim. And so knowing that United States courts, United States don't have that authority, then that what puts us in what? A position, all right, on what? Where we can now go. Where do we go to what? Argue our claim. And who do we bring in? We have to, you bring in what? Great Britain.
Spanish.
Because Great Britain relinquished. So that's why, so this is why I'm staying on this point, because you see the many factors. You see what comes, you see how this information, what I'm doing is I'm broadening it. so that we can be prepared and know how to structure suits. Knowing proper jurisdiction is a major part of understanding law. That's a major part in understanding law. Proper jurisdiction. Major part. If you don't know that, then you don't, it's not, because that's, no, I'm speaking, yeah, go ahead.
Yeah, I'm glad you said that.
Mhm.
And I didn't want to go off topic, but that was a topic that was discussed before. That was a
you're fine. That's what
that was stated. That was stated before, but it's something that you just said that I think just my aha moment, and just to be reminded that the United States does not have jurisdiction to address of the Moors because they are not the occupying sovereign. They actually were relinquished, as we know, the 1780s, the 1763 peace treaty between Great Britain, the parent, and United States, the offspring. So that is that relationship there. What part I think I was getting in a little confusion is that when you make the statement, now that we know the United States is not the go-to, and nor the United States court is the go-to, nor is the United States Constitution a go-to for the Moors, where can the Moors go to, since they are, from a collapsed nation? Like we're the sense of those people that have a right of claim, and we're trying to make that right of claim. And so where to go to is the international platform into the Family of Nations, and be recognized as an old and returning nation. Okay,
so you got it.
So
you got it.
My thing comes down to treaties, and again, this is what was taught in the early years, and I think it might have been adjusted a little bit, but I was kind of stuck on that, and that treaty relations. The treaties, and what treaties I was talking about, and I believe was getting a little confused, was the Treaty of Peace and Friendship and any other treaties dealing with the Moors. Now, there's the early, I think, what is it, Act to Protect Morocco, or some other treaties before, whereas there's responsibilities by these foreign sovereigns. There's responsibilities within those treaties. I think that part, I was misaligning a little bit. But the Treaty of Peace and Friendship, you're not to make the Moors slaves, that's in there. And I think I was stuck on that with saying, hey, there's a breach in treaty relations. Yes, it's that, but then it also is you have us under conquest and colonization, and you basically passed us off to each other, like a whore. You passed us off. I mean, so who's responsible for passing us off?
Well, Great Britain has a superior claim.
Occupated. Right.
Great Britain has a superior claim.
Nations, doesn't the other nations that had us up under colonializing, given us the tags, don't they share the responsibility? I yield.
No,
that's what I want to say.
But we're talking about this treaty, though. We're talking about the 1783 treaty. Like I can't bring Spain in, and talking about the 1783. Right. Yeah, you got it. Right. That's what I'm saying. That's why I didn't bring Spain in, because Spain's not.
I thought it was Britain.
No, we're directing specific treaty. England.
But even with that treaty, isn't it Britannia?
It's England first.
Oh, it's just England. Okay. See, I thought it was
England. No, all right. It's all right. Okay. England, Great Britain is England, Northern Ireland, Wales, and Scotland. That constitutes Great Britain.
Okay, so it is other people.
No, I'm saying great. All right. Before, it's still the same, because That's why I put England / Great Britain. That's why I put England / Great Britain, because it was 1607. 1607. There was no Great Britain in 1607. When it was England granted the charter to the London Company and Plymouth Company. It's England, not Great Britain, because Great Britain didn't exist. Great Britain is Northern Ireland, Wales, England, and Scotland. That's why I put England / Great Britain. But it's the same authority, though.
Can I add something, Abdullah?
Yeah. Yes.
So this is how we got to look at when we analyzing and breaking down law. First of all, when we talk about the source of law, that would be the treaty. And then we look at the subject matter under the applications. Those are principles in law, contract. So now we got to decide, okay, the two parties that's involved, their rights conferred in the treaty to determine where is the violations. Who do we address? How do we address them to repair the damages that have been that's been encroached by the other party? So now we got to lay out the claim. So what he's trying to do is show us, here's the source. Now let's look at the contract, analyze it. Now Great Britain is the authority that we need to look at. And now we need to address them, and then we have to look at what was discussed, because this treaty can be used as evidence. Now we can use it and say this is evidentiary to our claim. Now Morris can put in an affidavit saying, here's our claim, what we're looking at, and now we want to be able to make our claim to rights that's been conferred, and who is the contracting parties in which we can deal with. So we got to understand how to go about this dialogue and dissecting of this application so that we can better understand what Abdullah is trying to give you the vision to do. To address these things appropriate. This is what they call misappropriation. Misconceptions is the misappropriation of law, because you're applying law to the wrong parties. It's non-applicable. So you wanted to have the force. So who do you go to have the force of law? You have to bring the proper parties into the proper venue to discuss and hash out these issues. These are the things that we have to understand when you know how to properly litigate. So he asked the question, in relationship to a particular treaty, so that we can use the critical thinking aspect to make certain determinations based on the contract itself, where now we don't have to reach to other areas. He's referring to a specific document telling you how do you make these certain determinations? Based on what? This is about sound judgment, dealing with the contractual elements to say, here's what we need to point out, this is what we need to discuss, and these are the parties that's involved. Do that make sense to everyone?
Yeah, go ahead. You got anything else to add, King?
Just long.
You got anything else? Go ahead, Bro King.
So now when we do this, now I just want to just end it on this note. Now we just have to understand, okay, when we refer to the treaty, what provision in the treaty Or is it multi-layered violations within the treaty? Is it Article 1, Article 2, Article 3? What are we addressing? Because it could be multiple violations in the treaty that we need to discuss. But you got to have the proper parties, signatory parties, and the proper venue, because all of that's going to be discussed in the treaty. Where the venue, who has the power to decide, who's all of this is what they call in contract law trigger language. To trigger the jurisdiction, to look at everything, to make certain determinations. And we have to stay on point. Why am I addressing this? Because right now, we are doing the fact-finding elements. We are actually not only looking at this case, now everybody is pulling up the evidence so that when we address this, we can address this with one voice and to be accurate. This is not just, we're just studying just to study. And no, we're using, these are fact-finding tools, critical thinking exercises. So now when we go address these people, we know how to. So y'all need to very pay close attention to the details. The devil is in the details. So listen, when he asking certain things, we need to listen and pay attention to the construction of the directions that he's trying to get us to answer so that we can be better equipped. So when we see other treaties, we know how to analyze.
All right, you got it? All right.
Yes.
8 points, Pecola?
Yeah, again, I'm coming from that perspective of, okay, that's specifically where I'm coming from. And I'll give you an example. I had a lawsuit, and in that lawsuit, the hospital injured me. The people within the hospital injured me. When an attorney brought up the case, he brought up the case with a corporation. He did not mention the parties that injured me in that lawsuit, and therefore I had a difficult time with the really a right of claim, because the name of the hospital didn't injure me. So I'm being very specific also when I'm saying that I wanted clarity, because before it was taught that we had treaty relations with the occupying sovereigns, the colonial powers. It was taught before that we had treaty relations with these people. So that's why I say I did come in at a little bit of time, not exactly on time, I should say. So apologies for that. But the specifics of fact finding, absolutely, it is going to be in the detail. And so that's why in that, for instance, that 1763 treaty you're speaking about, it goes into talking about the parties in which territories would be relinquished to these individual 13 states. It gives it. And so I get that. But the question for clarity is it, because I saw it written Britannia, when I saw that, and this is some time ago when I was studying, it shows that there's several countries underneath that. So when we say, who do we make a right of claim to, or who do we bring charges, if you will, for the colonial processes, then I'm asking for clarity. Is it several other countries that should be spelled out on any kind of documentation that is being brought up? So should they be brought out by name? And that's what I'm saying. So that's the detail of what, the devil in the detail is really that question is that, can you tell for sure what those individuals at that time names were, nation states were, that had us in violation?
All right,
that had
pertaining to the
violated us.
treaty,
I yield.
England, once again, it's England. It's England. England is the one that granted. It was not Great Britain. Great Britain didn't exist until 1707. The Union of 1707. It's on one of the brothers
Got it.
posted it in the chat. The Union of 1707. But 1607, it's England granted, the English crown granted charters to London Company and Plymouth Company. It wasn't until 1707, which is the Union of 1707, which is Northern Ireland, Scotland, Wales, and England. That forms what's now known as Great Britain. The British Crown's dominion expands to Jamaica and the Caribbean, parts of the Caribbean. The British Crown extended to other parts of the world. The British Crown extended to what they call India. That's the dominions, as well as the Moorish Empire extended. All right, so we're talking about, so we're looking at, but it's Great Britain. All right, so let's go back to the text, Terrence. Let's go back to the text. This is I wanted to engage in discussion, more discussion this session, because pretty much even if we didn't get through everything, we pretty much getting through everything. This discussion is getting us through everything. This discussion is getting us through everything. Because the key is to make sure you're clear on this point. Clear on this. And so why the basis, the claim that this Constitution is the supreme law of the land, because you see here the land, because he's relinquishing, his Britannic Majesty has relinquished territorial rights. But the boundaries are in what? Outlined in the colony charters. So without this treaty, they have no claim to make this Constitution as the supreme law of the land. So now you're looking at it's relinquishing British sovereignty, and then here you have this United States sovereignty. But understanding how that its claim is made through this treaty. Without this treaty, they have no claim. This treaty is major. See, because they don't have the pomp and circumstance on July 4th about this treaty. You know what I mean? Declaration of Independence. You know what I mean? Declaration of Independence. You know, so they've heightened all that other stuff. And whereas this treaty has taken the back seat, not in the Supreme Court, not in the United States Supreme Court now, but in the public, it's taken a back seat. We're the ones that bring this to light. This is the foundation of their authority, this treaty. This is major. Let's take Terrence, before we go here, I'm gonna this is Godfrey. We'll come back to this. Before time runs out, I have several 4 or 5 paragraphs of People versus Godfrey. Let's skip to People versus Godfrey.
I did also put it in the chat.
All right, so you're gonna scroll down to People versus Godfrey. I have excerpts of People versus Godfrey. I'm gonna read that. Then we go back to it, because this is that ties in what I just. So Terrence is pulling up he's gonna scroll to People versus Godfrey. The People versus Godfrey, as he's getting back on the screen. That is the New York State Supreme Court. New York State Supreme Court case, 1819.
Can you
People
see it?
versus Godfrey. All right, Debbie, is that the first part? Yes, there we go. So we have a reader.
People versus Godfrey, 1819. New York State Supreme Court. Through Article 1 of the 1783 Treaty, the right of the English British Crown to the territory comprising New York State became vested in the people of New York in full sovereignty. The 1783 Treaty recognizes the boundaries of New York State and the Articles of Confederation, expressly reserve the sovereignty of each state. The New York State Supreme Court held that the fort was subject to the jurisdiction of the state since the lands upon which it stood had not been ceded to the United States. Chief Justice Ambrose Spencer wrote the opinion of the court in which he stated that it was beyond all doubt that United States acquired no territorial rights to any portion of the state of New York under the treaties of 1783 and 1794.
I continue, brother. I go. It's more. I have more people versus Godfrey. No, go continue.
Let me see if I passed it. Did I pass it? No, I didn't.
No, go continue. Go down. Let's go down. Continue.
Oh, here it is.
There it is. All right. Go ahead, brother. Continue.
People versus Godfrey, 1819, New York State Supreme Court continued in Article 1, Section 8, Clause 17 of the United States Constitution. The jurisdiction of the courts of the United States must be derived under the 8th section of the first article and 17th paragraph of the Constitution of the United States, which gives to the Congress exclusive legislation over all places purchased by the consent of the legislator of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings.
Stop there. All right, we gotta slow this down. Let's go back. By the consent of the legislator of the state, meaning that which gives to the Congress exclusive legislation over all places purchased by the consent of the legislator of the state in which shall the same be. Let's go back to Article 1. See what they're drafting. They're drafting 1787. They're drafting. They drafted that article, section and clause, based on what? By the consent of the state. Here you go, Article 1. See, by Article 1, they're drafting. So I'm showing you, not saying, I'm not telling you, I'm showing you that that's the Article 1 of Definitive Peace Treaty. That's the foundation for them to even draft by the consent of the state. Because what? Let's go to Article 1 again, Terrence. Let's go to Article 1 again. Can we have someone read Article 1? Here we go. You just passed it. All right.
Okay.
All right. We have someone read Article 1 again.
The 13 English/British colonies along the Atlantic seacoast. Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States. The 13/British colonies along the Atlantic seacoast. His Britannic Majesty acknowledges the said United States, viz. Latin for, namely, New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Maryland, Virginia, North Carolina, South Carolina, to be free sovereign and independent states, that he treats with them as such, and for himself, his heirs and successors, relinquishes all claims to the government, proprietary and territorial rights of the same in every part thereof.
All right. So it's the states that have the authority, not the federal, because if it's relinquished to each of the states. He's treating with each of the states. That's each of them are named to be free and sovereign independent states that he treats with them as plural. He treats with them. So His Britannic Majesty, King George III, is what? Dealing with each of the individual states and relinquishing so each of the individual states resume rights in the boundaries that's laid out in the respective county charters. The superior party is His Britannic Majesty. It's the superior party. He's relinquishing. The United States is not relinquishing anything. The United States is not relinquishing to His Britannic Majesty. These are his children. He's sitting down with his children. He sent his agent in France. His Britannic Majesty deployed his agent to France to sit down with his children. His children, subjects of Great Britain, were in rebellion. The video skipping, what do you mean?
Also, I think another thing is I think they were confused about the word relinquish. I don't know if people really understand what that word means. So I think they have to maybe understand the proper context of their words.
Let's go back to the treaty. Let's go back, bring it back up, Terrence. Bring it back up. Because we had this was November. This was the first Sunday in November. Terrence and I was on Brother Murphy's platform. Brother Murphy out in California. So Terrence and I was for the first time. I've been on Brother Murphy's platform about over 10 times since November. The first Sundays, every Sunday at 2:00 Eastern Standard Time. I've been on Brother Murphy's platform, his class, his Zoom class, over 10 times since the first Sunday in November. So the first time I was on, Terrence, give the story, Terrence. Give the story, Terrence.
Oh, which
the first time we were on, we were in your car, we were in your truck. We were in the truck. We was outside the house. We was in the truck, and the issue was of somebody wanted me, one of the students wanted me to, what does relinquish mean? I said, let's go to the treaty. No, give me relinquish. Let's go to the treaty. No, so I said, let's go to the treaty. Give the story, Terrence.
Oh man, this is a little foggy, but yeah, I think I kind of remember what you were talking about. Man, you caught me off guard.
You were sitting next to me, so
look, I have a million things going on.
I know, but I'm trying to jog your memory,
Yeah, I know, but I don't know.
Right.
Just keep going.
All right, keep on going. All right, so that was so I did not give the definition of relinquish. I refused to give the definition of relinquish. It was back and forth. Say, pull the treaty up. Just pull the treaty up. No, pull the treaty up. Give me the relinquish. Pull the treaty up. Pull the treaty up. So I got the treaty up after 10 minutes or 5 minutes of back and forth. So they read the treaty, and then they said, oh, I now see what you're saying. Our series was on. Vicerious was on too. It was Vicerious, DuPont, myself, Vicerious, and Terrence were on. And then it was the Terrence, DuPont, and Vicerious, were explaining to the brother my style of teaching. The brother got it. But it took all that for let's relinquish in the treaty. And he got it. Oh, I got it, brother. Thank you. Thank you,
Yeah,
brother.
I think the main focus you was trying to show him was that you didn't want him to say that Ab said it. You want him to see it for himself. You didn't want him to go somewhere and be like, yeah, Abdullah said this. So you showed him in the treaty the definition itself.
And also for him to understand what, what the relinquish versus ceding, means in that, in the treaty. Because when you start taking words out of, when you start picking and choosing words to use through your argument, you tend to, people tend to take it out of context. So when you read it in just like this says, His Britannic Majesty acknowledges said United States, viz. Everybody pass by, fly by viz, and then just start naming all 13 states, colonies, in fact. But never sit down to think.
They're states, Terrence. They're states.
States, yeah, states.
These aren't colonies. These are states.
Yes,
Remember, they got the same name.
I'm sorry. The colonies were, were the
two different entities.
Absolutely. But what I'm just saying, my point is that when we start, taking words and using them in an argument or whatever, but people tend to take it out of context. Oh, my screens went off. Hold on.
I get what you're saying, Abdullah. Read it in the context and how which it was used according to the language of that article or whatever.
And can I just add, I guess, why showing that it's really important is, for example, I have like a mini Constitution book at home where it just has like the wording in the United States Constitution and just like other facts about it. And in here it has a like chronology, and it speaks specifically, one of the dates is September 3rd, 1783. And it says, signing of Treaty of Paris, under which Britain recognized American independence and ceded territory between Allegheny Mountains and Mississippi River to the United States. So that's why it is extremely important to look back to those original documents.
King?
Yes, sir.
You got something to add?
I think when we read these treaties, one of the things that you also got to look at, very important, when you look at the treaties, right? If you're trying to decide who was working with who, anybody who signed as a signatory, they're going to identify who they are and what their status is. Is there an agent for what particular country, nation, or whatever? So you got to look at if they have plenipotentiary powers. What is that person's powers? Because sometimes you will have agents acting on behalf of kings signing off on treaties. So you have to read the treaty and identify, because if it's a multilateral treaty, they're going to state the people and the agencies associated with that treaty and who can sign. It's going to be identified in the language. So we have to understand when you look at the document how to read it, because it's going to be expressed in the treaty. So we don't have to. This is not a guessing game. This is not a guessing game. We're not guessing at nothing. We look at the document and interpret it for what it is and use it as evidence so we can make our claims and arguments.
This is why I implore and continue to implore us to read the articles, reference. This is why we went back we looked at Article 17. No, was that Article was that Article 1? Article 1, Clause 17, Section 3, Clause 17. And then I direct you right back to that to the treaty. We got 20 minutes left. Let's bring that back up, Terrence. We're gonna end on time. Terrence has to get up early.
All right, which one?
Bring the go back to the People versus Godfrey.
People versus Godfrey.
Where we left off. We're getting a lot done here because we got the people engaged.
All righty, here we are.
Mm-hmm.
Let me put it up on the screen. Place. Can you see it?
Yes. Continue reading, brother. Who was reading? Continue.
Okay.
Ronald Jones?
Yeah, I got it.
All right.
People versus Godfrey, 1819, New York State Supreme Court case continued. And Article 1, Section 8, Clause 17 of the United States Constitution. The jurisdiction of the courts of the United States must be.
You already read that.
No, he read the first one, didn't he?
No, he read that. No, we were there. We were there, Terrence. No, he read that too, but we were there. He already read that first paragraph.
Okay.
The second paragraph, Ronald.
Yeah, that's what I'm reading. The jurisdiction of the courts.
That's the first paragraph. The second, the only.
Oh, okay. No, well, I didn't read the first one.
Somebody read the first one. Go ahead.
Okay. The only evidence of a purchase of the United States of Fort Niagara from this state or of a cession of any kind by it to the United States is to contain in the act of the 6th of April, 1803, 1 NRL 197. The act authorizes the governor to agree with such person or persons as shall be authorized by the United States for that purchase, for the sale of such quality of the lands adjoined. Quantity of the lands adjoined the Fort Niagara as shall be necessary for the accommodation of that post, and to cede the right of the people of this state to be said lands to the United States, to oust this state of its jurisdiction to support and maintain its laws, and to punish crimes. It must be shown that an offense committed within that acknowledgement limits of the state is clearly and is exclusively cognizable by the laws and the courts of the United States. In the case already cited, Chief Justice Marshall observed that to bring the offense within the jurisdiction of the courts of the Union, it must have been committed out of the jurisdiction of any state. It is not, he says, the offense committed, but the place in which it is committed, which must be out of the jurisdiction of the state. It does not, therefore, enter into the consideration of this question that the prisoner and the decreases were in the service of the United States when the crime was perpetrated. On the whole, we are perfectly satisfied that the jurisdiction of this state attaches on the crime and extends to the person of the prisoner, and nothing remains but the judgment be passed upon him according to the law.
All right. Continue.
We consider beyond all doubt that the United States acquired no terminal rights to any territorial rights. Excuse me. Acquired. All right, I'm gonna start over. We consider it beyond all doubt that the United States acquired no territorial rights to any portion of this state in virtue of the treaties of 1783 and 1794, Treaty of Amenity, Comments, and Navigation between
amity commerce.
Okay, Treaty of Amity Commerce and navigation between Great Britain and United States, aka J Treaty. Neither of those treaties contain any words of grant to the United States as such, nor should we have submitted to accept as a grant what had already been acquired by our arms and established by the solemn Declaration of Independence. The Congress, under the Articles of Confederation, were the representatives of the several states, and having the power to make war and peace, were a party to the Treaty of Peace in behalf of the Confederate States, and every stipulation in the Treaty of Peace in behalf of the Confederate States, and every stipulation in the treaty inured to the benefit of the states in their sovereign capacities. When therefore it was agreed by the Treaty of Peace of 1783 that Great Britain should withdraw with all convenient speed its garrisons from the United States and from every port, place, and harbor within the same. That agreement was for the benefit of the several states within whose limits those garrisons were. The section of the Articles of Confederation removes every doubt upon this subject. It proves that each state should retain its sovereignty, freedom,
It
and
provides.
jurisdiction.
It provides. It provides.
Oh, it provides. I'm sorry, my glasses. I'm getting used to these glasses.
Mhm.
It provides that each state should retain its sovereignty, freedom, and jurisdiction and right, which was not thereby expressly delegated to the United States and Congress assembled. And it is not within our knowledge or belief that the United States have ever claimed or set up any pretension of property to any fort within the boundaries of a state under these treaties, ensure law come into operation, take effect.
That's what that means. I put that there. All right. All right. What else? All right. So we have 13 minutes. Any questions? We have 13 minutes. Any comments or questions?
I got a question.
Mm-hmm.
My question is, did Great Britain or England have the authority? Because I know they're trying to use the paper bulls, right?
That's it.
To usurp the Moorish treaties, right? Did they have the authority to usurp any Moorish treaties? Because from what I understand, they still had to go through the Moors.
Oh,
right?
yeah, you see that language. All right, so we want to direct people to sources. Now I have my book Moors and Masonry Part 1, and I have excerpts, I have listings of many treaties in there. I have excerpts of the treaties between Morocco and England, England and Tunis in England and / Great Britain, Algiers and England / Great Britain. So I have the listings of treaties between France and the Moroccan Empire, between the Netherlands and the Moroccan Empire. After those treaties are listed. If you look at the language, so that we can, once we're going to get out of King said or Abdullah said, we don't need to do that. Just go to the treaty. Go to the treaties themselves and read the treaties. You see in the language in the treaty, you'll see Moorish power being expressed in the treaties. So it's incumbent upon you to read those treaties for yourself. What King mentioned that deals with fact found. We need enough of us. We have to groom enough of us, a team of jurists, so that the coming of you to read those treaties so that we can be armed as a body. That's why we're having this study group session, these study groups, the Telegram groups. That's why I've done one-on-ones with many of y'all. right? So that we have to build up, and so I thank you, King, for your insight, your input. You add great value to this. You want to say something else, King?
No, that's it. My thing is like, we have to, when we listening to, I just want us to stay on focus. Because each treaty, right, is going to unravel and give us keys to other contracts. So the keys, right, are in the contracts to determine what else do we need to read. So if you don't understand one treaty, right, it can blur your other understanding of relationships with other treaties. So the point tonight, we trying to understand the definitive treaty between United States and Great Britain, and that to establish that relationship to determine what other relationships we need to look at to get the keys to our salvation. That's all I want.
Any other questions or comments? Go ahead. Someone has a comment or question?
Yeah, I do have a comment. So
Yeah.
I just want to take it back a little bit to when you were asking Terrence to express what the discussion was between you and a brother. And you said that the brother wanted to know the definition and you weren't going to give him the definition. So I just caught that as a point of just to make a remark on this. I've been out of school for a minute. I got higher education. When it comes down to reading treaties, nobody has it like that, not really. And so therefore the person that does have it like that and have a better understanding of a treaty or how it's being expressed, this is very helpful to all of us if that person would kindly give a better definition of certain things. So when you mentioned this, first thing I thought was like, wow, now I'm questioning, and we're talking about etymology and all of this, I'm questioning how the word was used in the treaty, like relinquish. Okay, so if somebody is asking for a definition of how it's used within the treaty, how it's applied, it sounds like he was asking for how it's being applied more so.
No, he wasn't, Pakula. He wasn't asking that.
Applied, right?
No, he didn't ask
okay,
that.
so even if
He didn't ask that.
even if he wasn't, my point, even if he wasn't, my point is that just imploring you to be sensitive to the fact that as we are examining documents and studying, a lot of us has been at the school for a while and studying in groups and studying in teams, it makes sense. Like right now, we actually have limited time whenever we come together, and so I'm open for anyone to get together with me to, even if it's just an hour or so, for us to kind of go over the treaty so that we're really solid on it. So when we come to limited time platforms like this, and we can be intelligent on what we're saying, and we know what we know, and we know that's the source. But again, sometimes it just made me think that, yeah, here it is. Somebody's asking a question on the definition, and you're pointing them to the application of it. And I'm like, I was already stuck in questioning, well, damn, do I really know what relinquish means? Like I need to go back and see how what definition it is and then how it's being applied. So I'm just saying to you is that those are little things that are have to be considered too, is that some of us may not remember. I mean, we can come out of our head what we think a definition is, but being able to really address these specific session versus, a relinquishment, these are really important, as we've been discussing, team building. We all have to know like what the application is. It's like, nice. I think nice is one thing, but we already know that nice in an earlier application means you're a fool. So anyway, I yield. I just want to add that in there that some of us may need a little bit more patience to explain stuff because we may have forgotten.
It's important for everyone to understand the outcome though, because that's important. The outcome was that the brother thanked me. He thanked me for that methodology. once the treaty finally was pulled up, after back and forth for 5 minutes, the treaty was put on the screen, and I had the brother read the treaty, Article 1, a definitive peace treaty between Great Britain and the United States. After he read the treaty, it was clear, and he thanked me on the methodology of the approach. Now, when I'm teaching the difference between relinquish and cede, what I would do, and we're going to do this, Terrence, we're going to pull up 1763 peace treaty between Great Britain and France. There's about 16, Terrence, the word cede appears about over 10 times, because Terrence highlighted it.
Yeah.
So I'm not cutting out my butt. The word cede appears over 10 times in the treaty between France, 1763 treaty between France and Great Britain. The word cede does not appear once in the 1783 definitive peace treaty between Great Britain and the United States. It's relinquished. I would teach it through that methodology. So we're gonna show that methodology, that you see the word cede is in this treaty here, because let's keep in mind, you have two sovereigns, two occupying sovereigns, two crowns, France, the French crown, and the British crown, that are what? Negotiating the 1763 peace treaty. Those two crowns. So let's look at the parties now. And between the 1783 definitive peace treaty between Great Britain and the United States, you only have one of the parties is a crown. One of the parties. One of the parties is a sovereign. One of the parties is a house. That's Great Britain. So all those keys matter. So we'll do that lesson. Terrence and I have talked about this over a year ago, and we'll make that lesson later on. We'll put together that lesson. All right. It's 8:58. All right. We're going to close out. I want to thank all of you for.
Hold on 1 second. One second. We'll just give time, because I want you to shed light on one brother in a second. But
all right,
Lawson L did have a hand raised. I just want to you can
all right.
Ask your question.
Gratitude and abundance, Terrence, for that acknowledgement, brother. Thank you. Brother, I definitely respect your method. I do not doubt it one bit. I don't have no complaints on that. And I'd like to share some light on what I think would be appropriate for Sister Coca-Cola. I know exactly what she means. Would you consider saying, trust me, and then just read it? And then that'll cut out on the 5 minutes that you spent going back and forth in that same situation. I don't know if it would have worked at that time. I'm just asking, just consider that thought in this moment. What do you think? Would that have made a difference in what he was saying? Like, brother, just trust me and read it. If you'd have said that, would that have cut the 5 minutes down to maybe?
I did say that.
Okay, thank you. That's all I want to know, brother. Respect.
All right.
Appreciate that.
Yeah. Right. Abdullah, I want you to shed light on what I'm bringing up now.
All right, Quasi. Are you with us? Brother Quasi.
Is he here?
Sister Kim. No, Quasi's not with us. All right.
All right, go ahead.
So, then I have to do it because Quasi's not here.
Yeah.
All right, let's bring it back up. All right. This is Uchavijima. Chivijima, that's Quasi ill. He's one of the one of the panelists of the upcoming May 18th Moorish Governance, Birthright and Nationality Claim Conference. So he'll be coming this way on May 17th to here to Philadelphia. This is the fourth annual, Tri-Regima's fourth annual Easter celebration. These are the helpers. These are some of the helpers, because some of the helpers had left. So this was towards the end. So this is some of the helpers that are along the side. And these are some of the children. He had over 100 children there. This is the housing project. So he didn't have it in a park and say, come to the park. He had it in a housing project complex. So it was in a housing complex. They had the parking lot, the area. This is a housing complex. It's the fourth annual. This was in New Grange, Georgia. I suggested to him to bring the children under the arms of the Declaration of Rights of the Child. And he had this banner made, and you see the Declaration of the Rights of the Child, the principle, and then he has the principle 3, every child at birth shall have right to a name and nationality. And he has proclaimed by General Assembly 1959, then has it's blocked there, but he has the 1979, the International Year of the Child. So this was whereby he brings the children under the arms. So now he's taking pictures of the children. This banner. He also had nationality games. So so instead of his having the children sit down, and sit down, children, I'm going to teach you a nationality. He did it through games. So we had a beanbag, a game where we had construction paper, or more Japanese. It was more Japanese, Russian, German, French, and they had to throw the beanbag on. They had to pick the nationality out of the box. If they pick more, they had to throw the beanbag. Beanbag has to land on more. They picked French. All right. So he also had Easter egg hunts. We had nationality. They were given prizes, monetary awards, and they had Easter egg hunts where they had nationality. So this is a way in which he was teaching nationality to the children. So this is the fourth angle, and like I said, it was over 100. I had gone live with him 3 times. We had a recap. That was the 3rd time after it was over, and so we went live on my platform, and then he also went live. He got a lot of community support. He had sponsors. So this was, once again, Quasi is one of the panelists for the upcoming May 18th Nationality Moorish Governance Birthright National Claim Conference. Sister Pocola Lee Kusar-Il did a slamming job over the past 2 Moorish Mondays. A slamming job. More part 1 and part 2. Part 1 was Monday of last week. Part 2 was this past Monday. On Moorish Monday with Abdullah Il Talib Mosibe on the Magna Crystal Pyramid YouTube page. We actually went an hour and a half over this past Monday. She did an excellent job. Slamming job. Pocola, you want to give them a look? You did, Pocola.
If I'm here.
All right, just give them a little something about the overall past 2 Mondays.
Oh boy. In a nutshell, you wanted me to speak
yes.
on you wanted me to speak on the matriarch principle,
the matriarchal
the significance of the woman.
Mm-hmm.
And so, one moment. So you want to speak on this, and
close your mic? Somebody close your mic.
That's her mic. There's a noisy background, Abdullah.
All right, that's all right. Good.
Yeah, I was coming from what triggered it actually was the book or the discussion by Vicky Dillard on the Sibyls, and the Sibyls was a primary matriarch rulership on the planet in different, on the planet in general, and even extending here in the Americas with the Popedess, or the diviners, or if you will, the divinators. And so the Vatican Vatican is actually sitting on an ancient site of the female seers. And so even before Christianity was in order, the seers were used as advisors to governmental officials and locals and so forth and so on. And so I thought that was interesting because she said that the Vatican still carries the name Vatican from those early women. So that caused me to go deep, a little deeper. I bought some books, and I found out that Vata it means seer. Vata, Vatis, it means seer. Khan means snake. So they were, and this is the African matriarchs were actually using, or the mother of civilizations, were using the snake as a tool for divining. And so with the taking over of the Catholic religion and so forth, they are actually using some of the prophecies of the Sibyls to have created the Bible and some other stuff. And so I was going into detail with it a little bit, reading it a little bit, and touching on the Iroquois Confederation, the Constitution for the Iroquois. Haudenosaunee, it tells you that the women own the land and the soil of America. And that was the 5 tribes that agreed upon that. And so they had to put the women in a place of respect, unlike the Patriarch Society in which we're in right now, which does not do that. And the women, again, women were used in advisories and so forth and so on. So I was discussing that. But then the second class we actually had, it was some Indians. It was some Indians that was coming on after me. And so I was expressing to the individuals that I'm an Indian too. So I thought through my family. And so I was just giving them reasons why and sources why Indians are British subjects according to the court ruling, the ICJ ruling, and from 1962. I'm sorry, 1926. So anyway, they were having a really hard time swallowing that pill, and in my delivery, and that's one of the things I try to do is I try to just try to stay in my feminine place with giving delivery so that it's not shocking people, because people will be shocked with birthright nationality discussions across the board. They will be, and they'll fight you. And we don't need fighting. We need complying. We need we need agreeability. And so that's what I was trying to do, is kind of come across. And so a couple of them seemed like they were coming to terms with the Indian thing, but you could tell it was a fight. It was a fight. It's almost like they're still hugging being Black, just hugging it and just don't want to let it go, So anyway, so that's what it was about. The platform host, I was Abdullah, but then it was passed on from, I forgot what the guy named, Crystal Pyramids or something. And so he seemed to be really intrigued with Brother Hank, right? He actually wanted to have us come on again and further this discussion on what has happened to the role of the woman in society and in leadership. This is MIA, missing in action. And so they want to encourage some truths of how the patriarch society has suppressed the role of the woman and so basically that's what this discussion was about. And I said to them, I began the conversation saying, I've had ex-husbands, I've had fathers, I've had grandfathers, and I've got brothers, and so I respect the role of the man in society. But remember, I also have I have a view from the colonial lens, but I just know from my mother how we're to respect the counterpart. And so I'm okay with that. But I wanted to make that clear because when women find out how, right down to the Vatican, you're sitting on the Sibyls, you've changed the doctrine of the Sibyls to be, appeared in the Bibles and all these other documents, and you're not giving credit where credit is due. And you do, like one of the scholars, there's two scholars who are discussing this in the Iroquois Confederation. I'm sorry, it's a document called How the Founding Fathers Ignored the Clan Mothers in Making the Constitution. So the Constitution, the very Constitution that we're talking about, the United States Constitution, got its structure, got some of its structure, selective part of its structure, from the Haudenosaunee Iroquois Confederation, and they wrote the women out. If they would have wrote the women in, the women, clan mothers, women would be in an esteemed place of government to this day if they hadn't, if the papacy had not done that. And so I was just, again, this is what our topic has been. I guess we're going to dig into it deeper. I've had at least 2 people reach out for classes, but I don't want to set it up where anybody has any animosity toward men. We need our men. We need our family structure. Men have been missing in action for a long time due to the colonial society. And so I know what I'm looking at, but I also want to, as we wake people up, you want to let them not hold any kind of bad feelings when it comes down. We have to be a family as we rise. So anyway, I yield. I just want to put that out there.
All right, thank you for that. Yeah, she did a slamming job. Y'all check that out on the Magnet Crystal Pyramid YouTube page. Magnet Crystal Pyramid YouTube page. I also put it on the Telegram page for the Love of Moors and the Moroccan Post School of Government International Law Telegram page. And I also sent the link out to everyone. I sent the link out to over 100, 200 people. So it's the same link, So check that out. And also, once again, thank you. We have the Moroccan Post School of Government International Law. The thank you. We have the YouTube, the Telegram page, the Moroccan Post Media YouTube page. Go check that out. The various classes. I advise you to go through the Moorish Treaty Protection and Consular Relations series course, and also through these. This is the 3rd part. Go through what I did 2 weeks ago and what I did a month ago. Go through these, take your time. Do not binge watch. Take your time, take notes, ask questions, write good questions down. All right. These are some very.
Can I ask a question?
Go ahead, brother.
All right. I just want, because the advanced study group, these classes they're not in like any of the group pages. I know it's recording. That's what I'm saying. Is there any way you can like maybe send it to people pages and stuff like that? Like
I put it in the group. I always put in the group page. Always. It is in there.
You sure? I looked in the group. All right, I didn't see like this class, like the advanced classes.
I posted this class. I posted the link to the night's class in the Telegram page for the Love of Moors. For the Love of Moors, I always do for the both. I do for the Love of Moors. That's my series. And the Moroccan Post, and I also sent it to about 70 people through their Telegram. I also text it to people. I sent it out to over 200 people. It will always be in the Moroccan Post School of Government International Telegram page. Always. It's on the Moroccan Post Media YouTube page, but I will always post. I post a lot of stuff. I must have posted over 100 things over there since I put it up there 2 months ago.
I'm going to recheck.
No, 215 things.
Oh, yeah. Probably that.
Put the study group pages. I'm not in the course page. So that's probably what it is. I'm in the Moroccan's group page. I'm on that page, but I ain't on the none of the other pages, I don't think.
Yeah, the Moroccan the school page, right? The school.
Yeah, I'm on that page.
Yeah, that's it. It's also the media page. The recording. The recording is will be posted on the Moroccan Post Media, and I will also put that in the Telegram page.
All right, I'll go back and
I thought I don't know if I thought I texted to you today, but we good. Let's move on. So we go to end. All right. So we have the upcoming. Get your tickets soon, everyone. Get your tickets soon. Go to my Abdullah Bay's Facebook page for the flyer for the Moorish Covenant National Birthright Claim Conference coming May 18th. All right. I'm looking forward to meeting Sister Mia Moore, who's one of the panelists. Looking forward to seeing Brother Viseers again. Looking forward to meeting Quasi for the first time. Brother Kono, though he's not on the panel, he's going to be coming this way. Looking forward to seeing him. Brother Lawson will be coming as well. So looking forward to seeing him. So and his wife. Who else is coming? Brother King Obey is I think it's a panel. I think on the panel or keynote speaker. I'm not sure, King, but Brother King will be coming this way. On May 17th. The meet and greet will be broadcast live. The meet and greet on May 17th will be for 3 hours, will be broadcast live, and 12 hours of live broadcast. So the program will be broadcast. We have someone that we hired that will be broadcasting, interviewing. 12 hours of the broadcast will be broadcast live. So we have the meet and greet on May 17th, broadcast live, and the actual conference will be broadcast live. All right. So thank you again. So we're going to close out because Terrence has to get up. I thank you for all your support and your comments, criticism. I'm open to criticism too. All right. So thank you again. Peace, everyone.
Thank you.
The flyer up. Here's the flyer. This flyer and the Eventbrite link is pinned on the Abdullah Bay Facebook page. So get your tickets now. You can share the flyer, post it pin it on your YouTube page. Thank you, everyone.
Peace, huh?
Islam.
Islam.
Islam, everyone.
Islam.
Oh, we got Sister Sasha. Hold on, Terrence. Hold on, Terrence.
All right, I'm here.
Right. Sister Sasha. I just saw Dr. Wordlad. All right, we got Sister Sasha. Sister Sasha is one of the keynote speakers. All right. You were at a program, Sister Sasha. Can you tell us about the program? You sent me a couple photos this morning. You sent me talk about the program. You were she's one of the keynote speakers of the upcoming conference.
Okay.
You tell us about the program, and you and your brother were in attendance.
Sure. This program that we were attending is connected with the United Nations and concerning a specific conference called Love and Peace. This is the 5th annual and is with Dr. Hung, which connects to Qigong martial arts, in addition to the preference of love and peace across the world. Of course, there's more aspects to it, but it's actually about many organizations, ambassadors, presidents, delegates of all over the world that are actually contributing to various projects, contracting, and so on to be able to initiate balance on a local level. And so this is a great opportunity to contract, to do more projects and pilot programs to initiate change and actually recognize autonomously the spaces that we live in.
Right. So Sister Sasha will be she's one of the keynote speakers. Who else is we have Sister Mia Moore is with us. She's on the panel. Who else? Son of Destiny. Brother Terrence. Brother Terrence is on the panel. All right. So we have Brother Terrence. All right. So looking forward to seeing y'all here in Philadelphia on May 17th, everyone. Peace, everyone. That's May 17th we'll have people at the hotel. People will be coming in on May 17th, and we'll be broadcasting live the meet and greet.
Peace and love.
Peace and love.
Indeed, Islam.
Love.